oludda olwabi lusabye ekiwandiiko ekiweeyo ng'ekizibiti kyabwe era abaloya b'omusi ne bakiwakanya.
The document was prepared and authored by MTN
ekiwandiiko ekyo kyakolebwa aba MTN ku Nkuruma.
Therefore, if it's tendered in as an exhibit, it offends the rules of tendering in exhibits. Let the author come to court and tender it in, not her.
Era kiba kimenya amateeka ag'okuwaayo ebiziti mu kkooti nti era omuntu oyo yennyini aba yakikola MTN baba balina okujja wano mu kkooti ne baba nga bakiwaayo.
Yes, Mr. Morgan, any rejoinder?
My Lord, does our land colleague want to specify which rules so that we respond from an informed point of view when he says this procedure breaches rules? Which rules, my Lord?
Yes, Mr. Kumbuga, it offends which law?
My Lord, right now I do not have the law, but the law of tendering in exhibits, especially documents written,
n'etteeka ery'okuwaayo ekizibiti ddala ebyo ebizibiti ebibeera biwandiikiddwa.
it must be the author,
alina kubeera oyo ye yennyini
and that law has not been amended to the best of my knowledge.
ekiwandiiko ekyo era etteeka eryo terinaba kubanga alikyusibwamu.
She can only identify that document since she participated in it.
Asobola just kubanga alabako ndabo bakugitegeera ku lw'ensonga ye kennyini yeetabamu okubanga bakutinga document eyo.
My Lord, the witness has clearly testified as to her telephone number.
Omujulizi adde obujulizi ng'akakasa era ennamba ye y'essimu.
And to the fact that she personally went
ng'era ye kennyini yali yagenda
to the telephone provider and secured her personal mobile money printout.
Kwabo bennyini abaali b'omukutu ogwo ogwa MTN asobola ye kennyini afuna printout okuva mu abo aba MTN.
My Lord, she also had earlier described in details the transaction on her phone
nti era yannyonnyola
on the day in issue.
Mu kusooka essente ezo ezaali zaateekebwa ku ssimu eyo.
My Lord, under Rule 25, 2F of the exhibit management of the Constitution, Management of Exhibit Practice Direction of 2022. A person who has sufficient knowledge of the exhibit is competent to tender it.
Omuntu aba alina obutegeevu ku kiwandiiko ekyo asobola naye okubeera nga akiwaayo.
In this case, my Lord, the witness has sufficiently not just described the transaction, but also the process through which she personally secured it.
Ng'era omujulizi oyo atunnyonnyodde emitendera gyonna gye yayitamu okuba nga afuna statement eyo.
My Lord, we believe she is competent in that regard.
Era nga tukkiriza nti naye abeera asobola okubeera ng'awaayo ekiwandiiko ekyo mu kkooti.
This is the ruling of the court in respect of this exhibit. I have listened to the objection that has been raised by the defense, and which is to the effect that the witness, PW7, is not the author of the document that the prosecution seeks to tender in through her, and she's therefore not the competent person to have it tendered as an exhibit. I've also considered the argument by the prosecution that the witness has testified to the processes through which the same was produced. However, I find that whereas the witness has clearly described the document by her mobile phone number and the number of the sender and the transactions of the day, it is also my finding that no evidence has been laid regarding the steps taken to having the statement printed. Whereas she testified that she was called by police to go and print the document, it did not come out clearly whether the request was oral in writing, and it also did not come clearly in her evidence as to where she put the document after having it printed. Did she keep it? Did she hand it back to police? That evidence was not adduced. I have taken note of Rule 25(2)(f) of the Constitution Management of Exhibits Practice Directions 2022, which provides that any person with sufficient knowledge may tender in an exhibit, and whereas I agree that the witness has sufficient knowledge pertaining this document, I don't find it proper that she should be the one to tender it in light of the fact that the chain of its movement has not been laid out before the court. It should either be tendered in by the author or the person at whose instance it was printed. I therefore decline to admit it as an exhibit, but I find that the witness has sufficiently described it, and I will admit it for identification, and it is accordingly marked PEID 2.